So refused classification items are banned from physical import into Australia, from sale and from public exhibition. Various other forms of distribution remain legal though. You can give these things away, you can own them, you can enjoy them in the privacy of your own home. You just can't do anything public with them. You can buy them, which is why even though Australia is the only country in the entire world to ban Dr. Phil Nitschke's The Peaceful Pill handbook, it is perfectly legal for anybody in Australia to go to Amazon.com and buy a copy. It's a refused classification publication, and who cares? It doesn't affect you. So refused classification isn't the same as illegal. It inhabits a grey area between the end of what's defined as being classifiable and the start of what's defined as illegal. So in the middle, we've got this subjective mess which is largely used to allow moralistic busybodies to ban things they don't like. Which is why when Bill Henson had his photographic exhibition early last year, one of the first things that happened is that those self-same moralistic busybodies rushed off to the classification board to see if they could get his photos refused classification. Because if they could, it wouldn't matter whether Bill Henson's photos were legal or not, they still wouldn't be allowed to be publicly exhibited. This is what refused classification is for. It is to allow people with not very much knowledge but very strong opinions to ban things that they don't like. It's completely unique to Australia. There is no other jurisdiction in the world that has anything like this. If you go to literally any other country, all legal content is classifiable. And the populations of those countries don't have a problem with that. So you have legal and illegal, and never the twain shall meet. In Australia, we have unambiguously legal and unambiguously illegal, and this little inconvenient bit in the middle that's mostly legal, but various people want you to believe that it isn't. This mess in the middle is the basis of the government's current internet censorship proposal. Now, applicants to the classification board who don't like their classifications can appeal to another independent board, which is called the Classification Review Board. In about half of cases, the Classification Review Board delivers a rating that's lower than the Classification Board. What does that tell me? It tells me that in about half of cases, the Classification Board gets it wrong. Each state has a dovetailing set of rules which say how each classification should be handled. So in South Australia, R18 plus films need to be segregated and their packages can't be displayed. This is a new law that came in at the end of last year. I think it comes into action on the 20th of this month.
Actually, it came in on the 10th.
There we go, thank you. In Queensland, Category 2 restricted publications aren't allowed to be sold. All the states ban the sale of X18 plus, but the ACT and Northern Territory reckon it's okay unless you're in a Northern Territory region that's part of the Aboriginal intervention, in which case R18 plus and higher is completely banned. It's another mess, okay? Depending on where you are, the things that you are or aren't allowed to do with a particular item of content will vary. You can use it perfectly legally and then travel a couple of hundred kilometres over a state border and the rules are different. And that's just for offline content. Internet content is a bit different. While classification of an offline submittable item is obtained by the item's distributor, such as the movie studio or the importer or whoever, applications for internet content assessment come from the Australian Communications and Media Authority, ACMA. This is important for appeals because if you are the importer of an item and you don't agree with the classification board's rating, you can lodge an appeal because you're the one who made the original application. If you're a citizen of Australia and you don't agree with the rating that ACMA has placed on an item of internet content, well, you're just some disinterested third-party observer and you have no ability to lodge an appeal at all. The only person who can appeal is the applicant, and that's ACMA, and they never want to appeal anything because it's embarrassing when they're shown to be wrong. So ACMA receives complaints from members of the public under Section 37 of Schedule 7 of the Broadcasting Services Act. Then ACMA must investigate complaints by assessing them against Section 20 or 21 of the schedule, which defines the terms prohibited content and potential prohibited content respectively by reference to the Classification Board guidelines for films. As I said before, the internet's treated like a film. So prohibited content is that which the Classification Board has said is rated X18+, R18+, or MA15+, and sold for profit. There are some complications due to restricted access systems. Some of the MA15+ and R18+ content can exist on the internet in Australia without ACMA getting upset about it. It really depends on how it's published. It doesn't depend on the content itself, just how it's made available. Potential prohibited content, that's content which hasn't actually been looked at by the Classification Board at all, but which in the opinion of ACMA would be prohibited if the Classification Board ever saw it. That only happens if the content is hosted domestically, because for international content, ACMA can just make up their own mind. They don't have to care what the Classification Board thinks. So prohibited is mostly a jargon term. It doesn't mean there's any actual prohibition. It's just an emotionally charged label. You can put a prohibited content stamp on something. And generally speaking, it doesn't affect its availability at all. It's just a stamp. Except for Australian hosted content. And that brings us to the next subject, which is censorship. Where classification adds metadata, censorship destroys information, or at least prevents access to it. It's almost the total opposite of classification, which at least purports to create new information which is likely to be useful to somebody in the form of a descriptive label. The Classification Board doesn't censor as such, it labels. If applicants want to censor themselves in order to get a different label, then that's their prerogative. But ACMA isn't like that. ACMA censors. Schedule 7 of the BSA compels ACMA to issue a takedown notice if an item of content hosted in Australia is prohibited or potential prohibited. ACMA can also issue a link deletion notice for Australian hosted links to prohibited content. That's what they issued on Whirlpool when there was a link in the discussion forum to the abortiontv.com website, because ACMA had previously decided that some of the content at abortiontv.com was refused classification. That makes it unable to, makes you unable to host a link to that content on an Australian web server. So under Schedule 5 to the Act, ACMA may issue an access prevention notice which compels ISPs to block access to prohibited or potential prohibited content unless overruled by a registered industry code. Now, when this law came into existence in 1999, on the very same day, Senator Alston accepted registration of an industry code which overruled ACMA's ability to issue access prevention notices. And because the BSA doesn't empower the minister to deregister an industry code once he has registered it, it's stopped, which means although the letter of the law says that ACMA right now can issue access prevention notices to ban content anywhere in the world from Australians, as of right now, they cannot issue those notices. So under the industry code for the ISP industry, ISPs are compelled to offer filtering software to end users who desire it, and ACMA is compelled to send notification of URLs of prohibited content to approved censorware vendors. Now, I can draw a distinction between what I would call filtering software. Here's that language thing again. Filtering software, I would say, is something that's under the control of a suitably authorized end user. You can change the settings on a filter. Censorship software is something where all the settings are controlled by the government's current proposal is to replace an existing regime of filtering with a new regime of censorship, where the ISP will be in charge, under the direction of ACMA, about which URLs you can and can't see.